All right, hello, ladies and gentlemen. This is Criminal Law CRJS312, and I'm going to be giving a lecture on Chapter 1. My lecture is going to be coming from our textbook, Contemporary Criminal Law. Of course, we have the latest edition that's actually the required textbook for this class, but I've cross referenced everything, so I'm going to be giving my lecture from the first edition. I'm sorry, the second edition of the book. I think we're up to edition for our class this semester. We are, I want to say, the fifth edition, if I'm not mistaken. I'll let you know now. Yeah, fifth edition. Uh, but I still lecture and everything from the first edition. I just like the way it's organized with the core concepts and summary statements at the beginning of each chapter. So it allows me to kind of bullet point everything and talk about the main points and keep it moving. Because the actual reading of the chapter is up to you. I'm just here to hit points and kind of bring some of these words to life and give you some understanding. So, Chapter 1, the nature, purpose, and function of criminal law. As an introduction, the criminal law is the foundation of the criminal justice system. The law defines the acts that may lead to an arrest, prosecution, and imprisonment. States punish a range of acts in their criminal codes. So, first, let's talk about the nature of criminal law. Crime is conduct, if shown to have taken place, will result in a formal and solemn pronouncement of moral condemnation by the community. That's how the book says it. When I explain what criminal law is and what crimes are, I explain it by saying, imagine society as a whole. Criminal law is nothing more than a contract between us as individual people and everyone else. In other words, it's that duty we have to follow certain guidelines as to protect everyone else that we have to share society with, right? So the reason murder is a crime is because no one else wants to get killed by you. So, so when you're charged with the crime of murder, you're charged with committing that act that is a breach of that. What would I say? I call it the contract between you and everyone else. So when laws go on the books and they're published, which makes them, which essentially technically puts everyone on notice. That is society's way of saying this is what you can't do in our society. These are the rules that we've agreed upon as a society, and you have to follow them. If you break them, you have to come before society to either explain why you broke it or say I'm not guilty of what I'm accused of breaking this law. And of course, then the state has the burden of proving that you in fact did. And if they can't prove having the burden of proof, if they can't prove that you violated the law, then you go free. So you're acquitted. So that's what we mean by formal and solemn pronouncement of moral condemnation by the community. I mean, so that's what we call jury of your peers, or you're brought in front of the people. The prosecutor represents the interests of the people. That's why in criminal law we say this: the people versus and the defendant, because you're charged with violating some code or some contract between you as an individual and us, the rest of society. So that's the nature of criminal law. Essentially, without criminal law does provide a semblance of order. In our society. So even everything from what side of the street we drive on and everything, all that stuff is law. So let's talk about let's talk about criminal and civil law. Criminal versus civil law. Civil law protects the individual rather than public interest. So when we talk about, remember, criminal law is a public interest. It's essentially saying you did wrong or you violated this solemn contract between you and the rest of society. The things that we've charged you and everyone else with doing to keep everyone else safe, or to keep everyone else from being violated. So when you're charged with the crime, it's you versus the people. In civil law, however, civil law is about protecting the individual interest. And so in a civil lawsuit, I'm saying, hey, even though what you did might also be considered a wrong to society, in civil law, I'm saying that wrong you did individually affects me, and I want to be made whole for it. So, so we had a contract and you failed, you breached the contract. I paid you a certain amount of money. You were supposed to do work and you failed to do so. So I want my money back. I want damages. So that's me versus you. So in a civil case, we talk about individual. You're essentially protecting and furthering an individual interest rather than the interest of society. Now, sometimes those interests can be the same. Sometimes a societal interest can be the interest of an individual, because this might be so. Like in the murder case, of course, if a person is killed or murdered, let's say the person that murdered them, of course, is criminally guilty of murder, right? If they're found guilty. But they can also be sued in civil court for wrongful death. So not only can they be convicted in criminal court and sent to jail, but the family, or the family or the surviving family of the victim can sue for wrongful death. And a example of this would be O.J. Simpson, of course. And before I even get to O.J. Simpson, let me talk about the differing burdens of proof. Of course, in criminal cases, because the stakes are much higher, it's essentially you versus society, or society versus you. So a representative of society as a whole, or the state, or whatever the governing or jurisdictional entity is now charging you and saying you did something. So they have the burden of proof. So because they have the weight of the people, because you're carrying the weight of the people essentially bearing down on you, the people or the representative of the state or the prosecuting jurisdiction, the burden of proof is what we call beyond a reasonable doubt, which is a very heavy burden of proof. That essentially means that for a trier of fact or a jury to convict you, they must be fully, in North Carolina, we say fully satisfied and entirely convinced of one's guilt. So that means that, these are fully and entirely. So those are unequivocal words. That's essentially 100% guilty. We shave off like a hundredth or something like that of a percentage and say at least 99.9% sure or of a person's guilt. So in other words, you're pretty much fully satisfied and entirely convinced that that this person committed the crime. So that would be the mathematical equivalent of beyond a reasonable doubt. Essentially 100, not anywhere between 99.999% and 100% level of certainty of guilt. Now that is a very high burden. That's beyond a reasonable doubt. So in civil cases, because the stakes aren't out as high, it's essentially an individual interest versus another individual. In civil cases, all the court can do is either grant some type of injunction or force a person to do something. Either you cease and desist, or you do this as the court orders, or you pay money, and you compensate them for what they lost. But it doesn't involve the possibility of jail time, losing your freedom, or even losing your life if it's a capital offense that you're accused of committing. So the burden of proof, the burden of proof is much lower. The burden of proof in civil cases is by preponderance of the evidence. What that means is essentially more likely than not. So if I was to explain it mathematically, that would be the burden of proof for it's not called a prosecutor in civil, it's called the plaintiff. The burden of proof for the plaintiff against a defendant in a civil case is essentially 51 to 49. So in other words, more likely than not. So if it's just a little bit more likely than that this person committed the civil wrong than not, then then the win goes to the plaintiff. So that's the burden of proof. So in other words, the scales are much more even. There's a lot less that's required for a civil plaintiff to win. So that's the burden of proof. The two burdens of proof. In civil, the burden of proof. In criminal, the burden of proof is beyond a reasonable doubt. In civil, the burden of proof is by preponderance of the evidence, or what we call more likely than not. So those are the two differences. Just like the O.J. Simpson case, he was charged with murder criminally because the burden of proof was so high. The state of California, the people of California, couldn't prove it beyond a reasonable doubt. But at the same time, while that case was going on, the families of the deceased sued O.J. Simpson in civil court for wrongful death. In other words, by his actions caused the death of those two people, and they wanted compensation for the lost lives. So it was a civil court. So O.J. Simpson won the criminal case. He was acquitted, but he lost the civil case. So he was found to be liable. So in criminal case, liability essentially means responsibility, right? So anytime, even when I say criminal liability, that means this person criminally responsible. So if I never use liability without some type of prefix word before it, like criminal liability when I'm using the criminal. But normally, when we talk about criminal responsibility, we use the word guilt. In civil, we just use liability by itself, or civil liability. So he was when it came to guilt or innocence in this criminal case, or criminal liability in the criminal case, he was found not guilty. He was acquitted. For the civil case, however, because the burden of proof was much lower, he was found liable for the wrongful deaths of Nicole Brown Simpson and Ronald Goldman. So of course, because he was found liable for their deaths, he had to pay out, the court ordered he pay out a large cash sum. So he had to pay back. So it was a lot of money. So that's what kind of led to why he ended up being in jail later on, but I don't have time to get into it. I just want to explain the difference. Now, the purpose of criminal law. The criminal law prohibits conduct that causes or threatens the public interest. It also defines and warns people of the acts that are subject to criminal punishment. It distinguishes between serious and minor offenses, and it imposes punishment to protect society and to satisfy the demands for retribution, rehabilitation, and deterrence. We talk about that further in the punishment chapter, about retribution, rehabilitation, and deterrence. So retribution means just rewards. You did something wrong, so that means you got to be punished. Rehabilitation means not just making the victim whole, but also filling whatever void or making the defendant whole. Because sometimes what I realize is people in the criminal system are not usually bad people. They're not usually just inherently malicious. Some circumstance in their lives caused them to make a bad decision. So sometimes people, because their life and the card they're dealt, sometimes in life every day it's just a difference between it's a one bad decision versus another one. So which terrible decision are you going to make? Sometimes it's two criminally bad decisions. So I decided to do this. At least this is a misdemeanor, not a felony. But I had to survive. I had to eat. So sometimes with rehabilitation, it's about maybe changing that person's life so they won't have those types of options. So that's where rehabilitation comes in, and then deterrence. The main purpose, that's the reason you're brought before the people. Like I said, the solemn pronouncement before the people, or as I said, but about moral condemnation by the community, is so that whatever punishment you get, if you're deemed to be if you're found criminally responsible or liable or guilty, or criminally liable or guilty of committing that crime, is putting everyone on notice. It's saying, hey, if you do this and you're found guilty, this is what will happen to you. So it deters other people and it deters you because you're punished. And if you're punished, you say, I don't want to go through that again. I don't want to have that adult timeout, or go to jail, as I call it, adult timeout, again. So I want to be free. So that means I'm not gonna recidivize, or I'm not gonna do that again. So that's deterrent. So we talk about that further in the punishment chapter. So let's talk about the principles of criminal law. Basic principles essential for understanding the criminal law include concepts of criminal acts, criminal intent, the concurrence between the act and intent, causality, meaning the action and the intent, the intent and the action had to cause a damage, and responsibility, and then you have defenses. So we're going to talk about all those in different chapters. So we're going to talk about the body of criminal law, the three things that have to come together at the same time for a person to be, to have committed a crime. And so we're going to talk about what a crime consists of and the types of crimes. So that's what we're going to be talking about. So this is a substantive law class, meaning we're going to actually be learning the definition of what's right and wrong. What is a murder? What we're going to learn about the parts of every, the two main parts of every crime. We'll go into it: a mens rea or actus rea, coupled with the mens rea. We'll talk more in depth about what that is, but that's essentially a criminal act, and paired with a criminal intent or criminal mindset that happens at the same time. So it's not just that you do something, but you do something with a certain intent or for a certain purpose. Or in certain situations, an intent isn't even required for you to commit the crime. It's just the act by itself, and we'll talk about that type of crime as well. So, categories of crime. Felonies are punishable by death at worst, or by imprisonment for more than a year, at least. Other offenses are misdemeanors. Some states provide for misdemeanor offenses that do not result in imprisonment. These are referred to as violations or infractions. So, of course, another thing we learned in criminal law is we have a hierarchy of different types of crimes, classifications of crimes. There's the less serious all the way up to the most serious. And as we talk about differing bodies of criminal law, we're going to end up breaking criminal law down into sections. We're going to talk about crimes against the person, crimes against life, crimes against property. When we talk about these things, sometimes the difference in the seriousness from when we go from crime to crime or definition of crime to crime, that's the hierarchy, whether something's considered a felony or a misdemeanor, and then we learn what the difference is, what graduates or aggravates one crime, differentiates one crime from another. Why is this treated more seriously than that? So we'll talk about that as well. Okay, mala in se, and that is Latin. Mala, M-A-L-A, then the next word I-N-N, and then se. Mala in se, in other words, malicious, just in the body itself. Mala in se crimes are inherently evil. Mala prohibita crimes are viewed as mala in se crimes are inherently evil, and mala prohibita crimes are not viewed as inherently evil. So what's the difference between a mala in se and mala prohibita? And the difference is in the word itself. Mala in se essentially means bad in and of itself. So there's certain crimes like murder that takes malice, like to kill someone, to take a life, even to steal, to steal something. That crime that is bad in and of itself. That act in and of itself is malicious. So it's malicious in and of itself. But then there's another group of crimes that are mala prohibita, meaning they're only bad because the law or the people have decided that it's prohibited. So it's only wrong because it's prohibited. So like possession crimes, or what we call mala prohibita. So if crack was legal, it wouldn't be bad or it wouldn't be criminal at all to have a crack cocaine or a kilo of cocaine in your pocket. In your book bag. Because there's nothing wrong with having the kilo of tobacco in your book bag, right? If you wanted to have that much tobacco, there's nothing wrong with having it. So the only reason the crime itself or your activity, even if it's just possession as a crime, is bad, is because the law says so, because it is prohibited by law. So there's a difference. There's something that's bad in and of itself because the act itself is bad, and then there are things that are bad because we say so, not necessarily because it's inherently bad in the action itself. So like I said, murder versus possession of an illegal substance. So with possession of an illegal substance, the crime is only a crime, and it's only bad because it's legally prohibited. So you're not supposed to have that, and we've deemed that to be dangerous. So that's an example of mala prohibita versus mala in se. So just remember that I use that in court. They weren't ready. It's like, oh, he knows something. But but yeah, that's what we talk about. The two different another category of crimes. Crimes also may be categorized by subject matter. As I said before, examples are crimes against a person or property, crimes against the state, and we're going to actually go through chapters later on when we talk about that. So the first chapters in this book are all just a breakdown. We're like this chapter, we're learning about the nature, purpose, and function of criminal law. Like, what is criminal law? What's it mean? Why do we have it? And then later on, we're going to build on that, and then we're going to slowly get into crimes. And that's the fun part, where we get to learn, what is this crime? What is this body of crimes? So that's when we break it down based upon criminal subject matter. And in most statutes and most crime books, state by state or jurisdiction by jurisdiction, that's generally how they categorize crimes. They group them together in the statute and statute numbers based upon how the crimes are categorized as far as subject matter. So we'll talk about that as well. So let's talk about sources of criminal law. There are a number of sources of criminal law, ranging from common law, which I'll talk about, and state and federal statutes, also to the U.S. and state constitutions. So there's a myriad of places laws come from. So first and foremost, the supreme law of the land in America is the United States Constitution. The Constitution itself creates our government. It is the basis for our government. So we're not a country. We're a constitutional democracy. In our economic base is we're a capitalist society, but our government itself, we're constitutional democracy. So we have a constitution that gives us guidance that says this is how we're governed. So that constitution is the law of the land. There's nothing that's gonna go higher than the Constitution. And there's nothing that's made by a state or federal law is ever going to abridge the Constitution. And if it does, the Constitution is going to change. It has to be done through the amendment process. That means it has to go through the Senate, and even the Constitution itself even outlines how to change it. So it's kind of a living, breathing document. We're going to talk about the importance of the Constitution, especially in Chapter 2, because even criminal laws themselves have to fall within the guidelines of what the Constitution allows. So the Constitution isn't just about how law enforcement acts and what they can and can't do, or what you can and can't do as a person, as an individual, but it's also how laws are written. Is that constitutional? So we'll talk about that later on. So that's the major source of all law, is the United States Constitution. Other sources are common law. Common law is nothing more than old law. So of course, before we became a sovereign nation, we were essentially what I would call an annex or a appendage of England. We were like England across the sea. There was a big ocean between. Is England? I call it England East and England West. So you had Britain, and we were kind of a part of the British Empire. And the British Empire had a lot of little countries everywhere. So different places where they had colonized. And America was a part of that. We were the ones that said we want to break away from England and have our own country. But in doing that, we still kept some of the criminal laws and stuff, and the social, what I call them, social do's and don'ts from England. So when we talk about common law, that just means a law that has come across the water, essentially. It's something very old, even before our country was a country. So when we talk about common law definitions, that means that's a very old definition. Burglary is a common law crime. Burglary has been illegal for a very long time, and the common law definition is what it is. And then, of course, now in modern law, we build onto it, and the law itself kind of morphs based upon what society and of course society grows, society gets better. We have technological advancements, and the law must advance as well. But a lot of laws start off with common law. So we got common law. You got state, and so the bulk of criminal law is determined from state to state. So the federal government, they have criminal statutes, but for the most part, the 50 states have their own governance. So in criminal court, the biggest part of the criminal court system is on the state level. Even in Greensboro, we have a federal court. in the Middle District of North Carolina, and then we have the state court, which is the Guilford County Courthouse. There are more people, there's way more traffic going through that state courthouse than there is the federal courthouse. Now, there are federal crimes, of course, there are federal criminal codes, but there are also state criminal codes. So that's the jurisdiction, either federal or state, saying what is legal and what's illegal within a certain jurisdiction. So you have state and federal statutes. So when they say statutes, that's nothing but codified law. When I say codified, that means law that is essentially booked and numbered so that it can be found. So when a law is made public, it doesn't mean they come in your house or call you and tap you on your shoulder and say, hey, this is legal now. The way they put the public on notice is they codify it and they say new law, it's in the books. So because it's in the books, you have a right to go look at the books. So that means you know, even if you don't know. So that's why ignorance of the law is never a defense in certain cases, because as an American, you have a right, and they put everything and publish everything and make it public in codes and criminal codes. So you have a right, just like everybody else, to go see what's legal and what isn't legal and what's new. So those are statutes. Then, of course, as I talked about before, the federal and state constitutions. So federal constitutions establish the federal government and the entire government, and also establish the relationship from state to state and how states treat each other. And then the state constitutions created the government of that state. And how the government, how within that state they're gonna do things, and what's gonna be illegal and what isn't, and what's constitutional. Of course, no state constitution can abridge the overall overarching federal constitution. So you kind of have to understand civics as well. So in other words, how is this country made? You have states that are individual corporations that incorporate themselves. Every state is incorporated. Look it up. You have the federal constitution. You have the federal government, or the federal constitution, that says, "Hey, we are the federal government, and all of you guys are attached to us as kind of subsidiary corporations, and your own sovereign states, and you work together, or that's why they call it a union. It's a union between 50 different corporations, corporate entities." So of course, that's why you have different jurisdictions. You got federal, you got state, then sometimes, and even within the state, you got local. So because in North Carolina, in the state court system, from county to county, there's no jurisdiction from county to county. So if you're charged with the crime in Guilford County, you're going to be prosecuted in Guilford County, and Guilford County has jurisdiction over you. So your Guilford County crime is not going to be tried next door in Alamance County. Now, in certain situations, if there's some type of what I call conflict of interest from the prosecutor's office, they may call on outside prosecution counsel from another jurisdiction to come in, or the Attorney General's office to come in. But for the most part, even within the state of North Carolina, from county to county, from judicial district to judicial district, they don't cross lines. So it's funny how that works. So that's kind of the hierarchy to step down. So that's sources. Those are sources of criminal law. The common law originated in the common customs and practices of the people of England, and can be traced to the Norman conquest of England in 1066 A.D. This law was transported to the American colonies. American states in the 19th century began to adopt comprehensive criminal codes. States today differ on whether they continue to recognize the common law in areas not addressed by the state statutes. Most states no longer recognize the common law, and there are no federal common law crimes. So, it's just the states. So, states possess the broad authority to protect the health, safety, welfare, well-being, and tranquility of the community. In 1962, the American Law Institute adopted the Model Penal Code to encourage and guide the uniform drafting and reform of state statutes. So that was kind of they got the smart people from the court system, the smart people from academia, and just other people from the community get together and kind of say, this is our model penal code. Now, model penal code just means that it's a model. So in other words, we want to try to get everyone to kind of be the same, but you can either choose to adopt it or not. But that's what, when we say, anytime we say model penal code, that's what we're talking about. It's a model, so you should model yourself after it, but the different states and different jurisdictions don't have to. Let me see. Okay, the U.S. Constitution assigns various powers to the federal government that form the foundation of the federal criminal code. The U.S. and individual state constitutions establish limits and standards for criminal law. So those are that is the nature, purpose, and function of criminal law. So that is chapter 1. So once again, make sure you read the chapter. I'm going to do the zoom in of the book again. So to prepare and do your reading and your supplemental learning for each chapter along with my lectures, you can go on the book's website. I would say go on the second edition website. I'll show it to you. You can click on and pull a chapter outline where you can skim and figure out what we're talking about in the chapter. Then you can also go to the online, in the online student resources, skim the chapter, pull the outline. They got like flashcard learning if you want to study and try to commit stuff to memory and learn it. And then they also have quizzes attached to each chapter, and that's between 10 and 15 questions. So if you go through after reading and looking at this lecture and do those quizzes, I'll say it after every lecture. That is my multiple choice question bank for every question, for all the questions on my midterm and the final for this class. So if you just go in and do that, you're preparing yourself, and you're gonna sit for the midterm, and you're gonna see questions that you've seen before. So that's a way. So it takes a little bit of work, but it's a little bit of work, so you can ensure that you get a perfect score on all of my multiple choice questions on my midterm and my final. It's all multiple choice anyway. So even if you don't read a lick, if you just listen to me talk and then you go and do those quizzes for each chapter, that you're essentially taking care of what between the final, which is 40%, and the midterm, which is 25%. That's taking care of 65% of your grade right there, just in going online and doing the chapter work and doing the looking at reviewing the outline and doing the quizzes for each chapter. And it goes chapter by chapter. So I'm going to zoom in and show you the website. See if I can get close enough. It's right here in this bright orange. Is www.sagepub.com/Lippman LIPPMAN CCL2E, and that CCL is Contemporary Criminal Law, second edition, 2E. So that's this book. That's the second edition book. So that's the exact website you can go to prepare for the exams for this class. Because the second edition book is essentially where I get a lot of my information from and I lecture from. So that's just a tidbit to help you to help yourself. So be good, everyone, and that is chapter 1. See you later.